So thank you, everybody. Welcome again. And Kirsten Barranti has the floor.
Thank you. I'm an attorney. I'm actually in Livermore right now, but my office is in Dublin. I've been in the Tri-Valley area for about, as an attorney for 20 years and a resident in Livermore since '93. So a few years. I want to just talk today mainly on employment issues. I do labor, I do business law also, but I want to hit some highlights. This is going to be fast. If you have questions afterwards, we'll have time for a question and answer session. If you feel like, gee, none of this I knew, you might want to attend. We'll talk about classes at the end. And then, of course, if you need legal advice, you'll know how to get a hold of me. So let's start with some cases and also statutes, which are laws that came into place this year. And one of the big ones is we've got new family leave laws. And those laws impact now anybody with more than 5 employees. And we had a law, it was called California Family Rights Act, and that's the CFRA, and that expanded to 5 or more. And the reason why that becomes important, because if you had something in your handbook that referred to the Parent Leave Act, this is what has replaced it. It is not a paid leave. Now we're going to say what we're going to have another paid leave slide here in a minute. But this particular law is basically a protected leave. So employees have the right, if they've met the minimum criteria, to take up to 12 weeks of 12 weeks of leave. And so a lot of times you'll see someone who maybe has been out on pregnancy, and they would be entitled to the pregnancy disability leave, and then they could dovetail into this CFRA. And I don't want to get too deep into this, but if you have someone that might be ill or taking care of a seriously ill person, they're now, if you have 5 or more employees, and that is a rolling number, meaning, you know, if you had 10 yesterday and now you have 5, you have 5, you know, for the purposes. Let's see here. You should be seeing PFL right now. Is that true? Up on the
Yes.
AB 2399. That's the paid family leave. And so that is basically the wage replacement. That comes from the state. The employee contributes to that. If someone needs to take care of a child or a spouse, they can apply through EDD. It also expanded to include a broader definition of what a military member was, because we have so many people that are still active duty. And so that has expanded. Now we have the other, kind of the third leg of the chair here. We have kin care. And kin care was, again, a paid sick leave. And if someone is ill, the employers used to be able to say how you can designate that sick leave. And you can't do that now without consent. Again, I'm going to refer you back into your handbook, make sure that that's compliant, because there is a consent issue that goes along with that. And then going back, like I think 5 years now, just a reminder that every employer, regardless of size, is mandated to give a minimum of 24 hours or 3 paid sick days per year. And that can either be accrual or you give a lump sum. So And I bring that up because I have new clients that come in all the time that haven't been doing that and haven't been tracking that on their time card. So let's talk about, this one I'm going to talk about just because I have a lot of people that decide, well, we're not doing things right over here, we're going to set up a new company. Or we've set up a new company and they think that they can avoid a judgment. And now if someone sets up basically the same company with the same facility and the same owners, same industry, you're going to still have that judgment out there and they're going to be able to enforce it against you. So there's no more kind of skirting around those and setting up new entities. And I bring that up because, again, I've had clients that either asked me to do it or have done it, and now someone's trying to do a money grab. Our favorite, I'm sure, later on today, I know Stanford's talking about the vaccines. Coronavirus has all consumed us in more ways than one. And so there's a lot going on. So this slide is a highlight, but basically what has happened is because some industries more than others have not taken various steps to protect their employees and have mandated that they come back in. On January 2020, there was a bill, the 685, that basically says, look, you as the employer need to notify employees. You have one day, one business day to do that, to let the other employees know that there's been a potential exposure. The other piece is if someone reports you, so someone says, I think there's a problem here, you need, to figure out, do you have a plan in place? So you have an obligation to create a plan of how you're going to deal with a potential exposure and how you're going to get that information out. That dovetails into, do you have a plan for disinfection and prevention? Both of those things are required. Now, Alameda, I know Dr. Moss, right? He comes on here regularly and talks. If you go to their website, they have a template that tells you exactly, what needs to be in that plan as far as, proper public health. But the reason why I bring this up is because now we have workers' comp. There's a presumption, it's a disputable presumption, that if someone gets ill, that from COVID, that it's a work comp issue. So you do need to notify your work comp carrier. And here's the standard. When an employer knows or reasonably should know that the employee has tested positive, they need to, within 3 business days, let that carrier know. Also, if you have an outbreak, so for the small employers here, that's less than 100 employees, and you have 4 positive, you do need to let public health know, and then you'd also have an obligation to let the carrier know. If you don't do that, the labor commissioners, and they are going out and doing enforcement on this, you get civil penalty of $10,000. So it's super important. If you don't understand this or you don't know it, we can get you to the public health, in Alameda County. Certainly you can call me, but there's a lot of resources, to either A, get the written material done, or B, how to do it and carry it out in the workplace. So the other thing I'll just touch on real quick is vaccines. So now we're now going into the phase where people are going to start, once we get through the 65 and 75-year-olds, we're going to have regular workforce. And so the question is going to be, can you mandate, an employee to do that? As it stands right now, the answer might be, and this is a lawyer answer, not an absolute, we might be able to mandate that all your employees get vaccinated. Now, there'll be an exception for health reasons or disability or religious, but I would say stay tuned. The EEOC has given some guidance on this. So what we do know is that, the ability to travel is going to probably be limited if you don't have a vaccine. But you will see more about this, so kind of keep your eyes open for that. Minimum wage, if you didn't hear, minimum wage changed on January 1. Two different classifications. So you have over 26 and fewer than 26. That also then impacts, keep in mind, the exempt status, because it's a 2.5 times, when you calculate what the minimum wage is then for a salaried exempt, that number has to meet the minimum wage that's in effect at the time. If you're working in, for example, City of Alameda, starting I think July 1 is going to have new minimum wage. If you're working in San Francisco, they have different. So you do need to be aware of what those minimum wage ordinances apply. So a couple quick court cases, because I do want to give us some time. We had Apple, always in the news. This was a case where employees that come to work and they have bags or briefcases, and they would have to stand in line, and there was a search out component, and sometimes that would take up to 45 minutes to get through the line to leave work. And so the question was, when you have a search, a mandatory exit search, do you have to pay that employee? And the answer is yes. So if you have anything similar to that, where, you may, I'll give you an example. You give them a vehicle and you have to go through the vehicle to make sure the vehicle is acceptable at the end of the day. And they have to wait for you to do that. That would be compensable hours worked. The other case is, there was a trend, and I think we started talking about it maybe in 13, 14, 15, where it's unlimited vacation, and everybody goes, oh, I can just take as much time off as I want. You can impose limits. I would say if you're going to go down this path of unlimited vacation, you need to have a policy on it and what the expectation is, because the courts are not going to pay out a year of vacation. They understand that that's not unlimited, but there needs to be what, you get your work finished. If you don't get your work finished within, a 5-week period, or, you left work, they will impose, a reasonable limit on it. But I would say that this trend, the unlimited vacation, is probably on its way out after COVID. Two more quick cases. This was a case where they had a hiring situation, and they did a background check, and there was a criminal conviction. And the question was, did the employer have an obligation to check it out? And the answer was yes. And before they terminated. And I've had several clients where they've done a background check, they haven't waited for it. It came in, and then they, what's called revoke the offer to the person and terminated them. So if you're doing background checks with criminal and there's any chance, you know, ADP or some of the background places are not absolute, I would say you'd want to double check when there's something in them. Last case real quick is a case where there have been confidentiality provisions, meaning you can't, because it's so narrow and there's so much trade secret, they're basically saying that's acting as a non-compete. There was a bill introduced in our House yesterday that is probably going to maybe eliminate even NDAs. Again, that's not a law, it's being introduced, but the NDA and the confidentiality run hand in hand. If you have a confidentiality provision that is so narrow that when someone leaves, they can't really go work somewhere else, it's probably not enforceable. And so you'd want to look at revising that to be compliant with this Brown versus TGS case. This is a reminder, January 1. Last year was supposed to be the deadline. They extended it to January 1 of 2021. If you have 5 or more employees, the supervisor needs 2 hours of training, and the non-supervisor needs an hour. I apologize, Christy. The Department of Fair Employment and Housing, let me give you the exact website, but it's www.dfeh.gov. Probably the easiest way is to put DFEH and sexual harassment in, and it will take you to their website. They're the actual government agency that has mandated this and required to carry it out. So you don't have to pay anyone for a long time. You had to have attorneys or professionals do it. You can go on that website and satisfy that training. And so we have a few minutes left. Future classes we're going to cover. These will be a little bit longer. You know, for example, hiring, looking at, you know, what does it mean to hire? There's a new regulation that came out this year on language, you know, that you put in for hiring language. And so we'll talk a lot about that. We hit on a little bit of leaves. We'll look at, you know, medical leave, personal leave, you know, not paid leave, disability leave. Wage and hour is a big one. Everybody wants to talk about AB5, which is basically Dynamax. It's the independent contractor situation. So those 2 classes have been broken up into 2. Favorite, discrimination, harassment, and then how do you get rid of someone? And by that time, we're at the end of the year. Hopefully we'll have no COVID and we'll get ready for 2022. And so we have time for questions. And so what questions do we have?
Anybody?
This is Susan from Visit Tri-Valley. I have a question on the reporting COVID cases to the county and to workers' comp. We've been sheltering in place since the 17th of March of 20. If our employees have not been in the office and we know that they contracted COVID not through a work situation, do we still need to report to workers' comp?
So I would say no. You know, if none of you have been together, there's because the presumption is it's a disputable standard. So it would. I'll give you another easy example. You're a big company, but you have the one person in California in no office, and the person contracts COVID. It's not going to be a work comp scenario because there was no way to contract it from other people in the office. The issue is, are you contracting it from other personnel in the office or customers or vendors? And so,
Thank you. That's the way I interpreted it as well. Thank you so much.
well, anybody else?
Haiti, did you have a question? Anybody else?
Yeah, Shane Dake here. I have a quick question for you. I think I know the answer, but maybe you can expand on it. And this probably dovetails to the Apple, the Freakin or Friken, whatever that is. Due to the COVID restrictions, including PPG and PPE, health and testing, would there be an extension of required pay for employees who have to queue up either before or after their shift in order to move their protective gear and or be tested or have their temperature taken, whatever? I know on some of our job sites, we're actually able to charge or pass on almost a full hour client based on those concerns.
So your audio was kind of weaving in and out. And so if I understand you correctly, you're asking, there's things that have to be done at the end of the day because of COVID, whether it's cleaning or gathering up supplies. Is that what you're saying?
Yes, either that or before, so that the employee is done with their day, but they're still not on their time. Are they eligible to be paid for that time?
So the answer is yes. So the standard in the law is called suffer, or they're under your control. You have an expectation as the employer to have them do that. So then it becomes compensable time. So the answer is yes.
Hello, this is Deanna. I sent 2 questions on the open chat. Can you see those, Kirsten?
So let me see. I'm not seeing the chat for some reason.
I can tell you what they are.
Okay. All right.
If you could please repeat the website for the sexual harassment.
Oh, sure. So it's, so I'm going to say the full name, and then I'll give you the initials. Department of Employment and Fair Housing. And then it's dfeh.gov.
Okay, and the second question that she has is where to get the template for AB 685.
So that template is on Alameda County. So go on to Alameda County Public Health. And I'll look at my, here real quick. So, so Alameda County Public Health, COVID, and I would put in template. And that should bring that up.
Thank you so much. I appreciate it.
The other place you should also look when you're developing it is also at the CDC. So I just pulled this up, and it has, it's 12 pages. The other key words that they use on Alameda's website is, it's called a site-specific protection plan.
And underneath the AB 685, is it a ruling where this has to be available now, this plan? If anybody should ask on all of our job sites, do we need to have it on the ready?
So this actually came into effect, I believe, if you can imagine, back in, I believe, May, because there was a predecessor to the actual 685. So the answer is technically yes, you should have that together. If you look at the site plan, my guess is most people, when I talk to them, they're actually already doing this stuff. They just don't have written documentation.
Yeah, we are already doing it, but I hadn't done it under any template, so I'd be curious to look at the template to see if I've left anything out. And then, how often are there changes? Should I be looking in a particular area for updates regularly?
So I would look on Alameda County Public Health periodically. The site plan has not changed in probably 6 months. I would say that some of the recommendations may change as the tiers change. So, for example, as far as like riding in cars together or social distancing, those things are going to change as we start to come out of COVID. But those two websites, the Public Health, Alameda County Public Health, you can also look, although it's not as specific, California has a public health website also.
Thank you.
You're welcome.
Yeah, Alameda County is the place that the chamber goes to. We get all of our information from that website. They send us everything. And then some of you may know that we have, back in March, we launched another website, and it's all COVID related. So it's all, we were posting all of the information that we received from Alameda County. And it's just, there's a lot of information there. There's even there's a section for businesses that are open, and businesses that, and what they're doing, is it only curbside, what their hours are, et cetera. So it's an excellent website, livermoreupdates.com. And it's just, it's anytime we get calls on any of these things, we always send them to that website. It's our go-to, because it's just, it's everything we need. Do we have any more questions? Anybody? Okay, we'll wrap it up then.
Quick.
Thank you, Kirsten, for this overview, and we look forward to the other workshops in the series. And the next one is on March 9th. We will be putting the registration up so that you'll be able to register as soon as possible. And I think that is it. Martha, do you have anything, or Kirsten?
Thank you for allowing me to present.
That's it. Thanks everyone.
Yes, and if you like this brief presentation, then certainly give Barranti Law Group a Google review, and the Chamber a Google review. We'd love it. We'd all love that. Thank you for coming.